Well, good morning. I'm Roy Harriman with Ministry Pacific, and thank you for joining us today in this webinar focused on a new California workplace law, Senate Bill 553. This law requires the state's workplaces to create a plan to prevent and respond to workplace violence. Ministry Pacific, all of our clients are churches and nonprofits, though I understand some people on the webinar today may not be in that category. That's all right. This law is going to apply to you as well. We don't tend to think of churches and nonprofits as workplaces, but they are indeed places of employment and are governed by labor laws. I want to introduce our subject matter expert, Ryan Abernethy, an attorney and shareholder at Weintraub Tobin in Sacramento. Ryan, thank you for joining us today.
Yeah, thanks for having me, Roy. I'm excited to meet with you and your group today to talk about this big development.
Well, we appreciate you sharing your expertise. A quick word about who we are. Ministry Pacific is an insurance broker who works exclusively with churches and nonprofits. We're a broker, so we're not an insurance company, and that means we work with insurers to find the best property, liability, and specialty insurance that you need to fulfill your mission. We also consult with clients, educate them, and help with claims. This webinar is part of our service to the faith and nonprofit community. Now on to what you are here for, our subject matter expert, Ryan Abernethy, not Abernathy. Abernethy, am I correct?
That's correct, Roy. I think I mentioned to you earlier, somehow they got better name recognition than us, the Abernathys, but yes, I'm a Nethy.
Okay, all right. But he is an attorney and shareholder at Weintraub Tobin, a law firm with locations throughout California. He's a member of the firm's labor and employment and litigation practice groups, and we're delighted to have his expertise today. Ryan, why don't you begin by telling us about Weintraub Tobin and your particular area of practice?
Just to introduce myself, I've been practicing as a labor and employment defense attorney here in California for approximately 15 years. And I've handled just about every conceivable employment issue involving, workplace discrimination, harassment, retaliation, wrongful term, wage and hour stuff, all this labor code stuff we'll be getting into today, trade secrets and class actions. So I've seen a lot of what employers have to face here, including religious employers. I also provide counsel to my clients regarding compliance and risk management and policy preparation, employee training. And particularly relevant today, I often have to get workplace violence restraining orders for some of my clients. But I do represent many religious organizations, and I've gone all the way to the U.S. Supreme Court actually on the issue of the ministerial exception in employment cases and to what extent the Constitution preempts the application of certain employment laws.
Thank you. And thanks for the background. That's very fascinating and obviously very relevant to what we're doing now. As we look at this workplace violence prevention law, we have to obviously set out the definition of what is a workplace. As I mentioned in the preamble, we don't often tend to think of churches and nonprofits as workplaces, but for the purpose of this law, just to be clear, they are workplaces. Is that right?
That's correct. Yeah, and let's take one step back,
Sure.
first, kind of by way of background for this SB Senate Bill 553. So what it does is it adds and amends certain sections of the Civil Code and the Labor Code. And employers were already required, and including religious employers, to have an injury and illness prevention program under existing law. So SB 553, it adds a workplace violence prevention plan with certain parameters we'll be talking about today to that IIPP, the injury illness prevention plan. A lot of long words, so I'm going to try to use acronyms if we can. But again, there's a new labor code section added that really details what this workplace violence prevention plan needs to look like. Now, to your question about whether churches and nonprofits are workplaces under SB 553, yeah, the answer is yes, to the extent they have employees. So the labor code and this statute in particular does not draw a distinction between employers generally and religious organizations or nonprofit employers.
Good to set that out. A lot of times, as I'm sure you know, misinformation is difficult to combat. And if someone over in San Bernardino says, "Oh no, churches are exempt from that," we need to set out what the facts are. So along that line, this has been an issue that's come up with AB 506 relating to child protection in child serving organizations. Is a question of, well, are there exemptions for me? Everybody with every law that's ever passed is looking for a way to get out of it. Is anyone exempt from this law? I know people probably listening right now with their fingers crossed.
Yeah. Well, look, it makes sense, right? Before you get into the law, you want to see if it applies to you. So, yeah, it's good to get the exemptions right off the bat here, I'd say. Okay, so we'll go through. There are categories and particular types of employers that are exempt. There's approximately four of them. So the first is facilities operated by the Department of Correction and Rehabilitation and law enforcement agencies. So basically, prisons and police. And the second one is in the private sector, healthcare facilities. And these are exempt because they're actually covered by a separate pre-existing workplace violence statute. And there's also a third exemption covering teleworking employees. And you can see how that would make sense. This is remote working employees, right? And this makes sense because it'd be very difficult for employer to regulate the safety of workplaces that employees choose to work from remotely, right? And lastly, and the only one that might apply, I think, well, I guess to the extent of anyone here is operating healthcare facilities or has teleworking employees, the last one is exemption for certain small employers. And that's very narrowly defined. The small employer exemption is a bit vague. It should only be exercised with particular care for some reasons we'll talk about here. It's limited to places of employment where three elements are met. So the first is there have to be fewer than 10 employees working at the place at any given time. So that means 9 or fewer. And two, there are not the workplace has to not be accessible to the public. And third, the employer complies with the injury and illness prevention plan and the Cal OSHA regulations found in another section of the California Code of Regulations. So to the first element, again, the 10 employee or fewer than 10 employees, while the labor code defines employees as anyone who falls under the ABC test. And I don't know if anyone's been following or watching the bouncing ball on that one, but California's had some big developments recently as to, an expansion of what's considered an employee. So a lot of folks who we previously thought were independent contractors or volunteers may in fact be employees under the labor code now. So, and again, that's the entire workforce is in some instances. A lot of my litigation surrounds that particular issue. In addition, there's also the civil code section includes as employees, volunteers, independent contractors. While the labor code section about the workplace violence section doesn't necessarily include that, you could see how a court could, decide that volunteers and independent contractors could fall into that head count. Again, all these are just reasons to be very cautious for that first element. The second element is, again, whether the workplace is accessible to the public. And the statute doesn't define what that means at all. So what is certain by way of this small employer exception is that if you have 10 or more employees working at the place at any given time, then the small employer exception doesn't apply. In addition, even if you have fewer than 10 employees, but the workplace is accessible to the public, whatever that means, then the small employer exemption doesn't apply. And lastly, even if you have fewer than 10 employees, and you are not accessible to the public, but you don't comply with the injury and illness prevention Cal OSHA regulation, then the small employer exemption still doesn't apply. All three elements must be met. And again, just to make it exquisitely clear, there are no exemptions or loopholes for religious entities.
You referenced this. It might be helpful to speak about at least what we know or can clearly interpret about the volunteer component, or just reiterate that for those how volunteers may or may not be included among that number of people. So if you have 8 employees but a large volunteer pool, does that matter? Are those people under this law, are they part of that group number and people who need to be protected by workplace plans?
It depends on what definition of volunteer, right? Volunteer under the labor code is a very specific technical definition. I mentioned the ABC test, which now might cover a lot of these folks who would be considered employees. But yeah, I'd say I'd look very closely at that. I'd be very cautious about if you're ever going to adopt the protection of the small employer exemption, make sure, because yeah, there are certain situations where volunteers wouldn't be considered employees. But I can definitely envision, very fact-specific situations where one of these volunteers might be considered an employee. I could also envision down the road where they say, well, employee was broadly defined to include these types of folks. That seems not entirely clear at this point, but that's kind of the nature of new statutes, right? We have a lot of question marks, and we're kind of left with the bare language of these new statutes. And the question is, do you want to be the one who's writing the law through the court system, and what your risk is, for what your risk tolerance is as an organization?
On things like this where things are a little bit gray, is it better just to move in that direction, or does it just depend, or can you really say?
Yeah, I mean, without, giving legal advice to anyone individually, it varies a case specific instance. And sometimes it comes down to a business decision. Certain regulations are just, they have exemptions for small employers for a reason, because it's not feasible for them to follow and comply with some of the reporting requirements of a very big company, right? So sometimes it's just almost impossible. As a lawyer, I see litigation all the time, so I see things fall apart. I see agencies coming after companies. So to the extent possible, I'd usually the encouragement would be, take the conservative approach legally and try to comply with these things if we can. And in this statute in particular, there's certain regulations, and I'll talk about this a little more later on, I think, if we get into it. But there's certain statutes that there's really not a benefit to the employer for compliance. It's purely regulatory red tape, kind of almost it's just landmines for employers to step on is all it is. In this statute's a little different. There are a lot of potential benefits to compliance, right? Potentially life-saving benefits. So I'd say for that reason, there's a lot of help and potentially writing off other potential liabilities because you have a safer workplace.
And just to be clear, often when we're talking about houses of worship and violence, people's mind automatically goes to a gunman who bursts into the auditorium and starts shooting, or in the parking lot. And this isn't talking about what's usually called church security, which is related to keeping bad guys out of events. And
that's correct, Roy. Yeah, the statute actually breaks down the type of applicable workplace violence into 4 categories, and all of which address violence directed at employees. It's a labor code regulation, right? That's where all these regulations are coming out of. So naturally, its protections are employee centric, and the focus is not on customers or non-employee congregants. However, you could easily see how an act of violence like the one you described, that occurs against members of a congregation or a work site, for instance, could very well be covered under this statute if it in any way involved or was related to or threatened an employee of the church, even if the threat was only coincidental or remote to the otherwise greater threat potentially to the congregation even.
Let's take a look at the law itself and start looking at the components. It requires workplaces to create a plan to prevent and respond to workplace violence. And many people on this webinar may be saying, well, how am I supposed to do that? I went to seminary, not the police academy. Where does this information come from? How do you get started?
But, most of the employment statutes and regulations that come out of the California legislature or the labor commissioner, again, they do make me feel bad for my clients that it's just, like I mentioned, kind of landmines around them. And they just pile on additional costs and liabilities that they have to strictly comply with these regulations. And by the way, the labor code, as a reminder, is usually strict liability. So they don't even care if you're mined, if you I didn't intend to cause harm, or I didn't know about the law, right? It's the labor code is large part strict liability. I mean, did you have to apply by it? Did you abide by it? You know what I'm saying? There's no real defense there. But I mentioned, I think, at least in this case with this regulation, there are some attendant benefits that the congregation, the employees can all experience by compliance with this. But now back to your question about, how to create a plan, with the understanding that we're not experts in this. This is a very new area that most anyone here is having to think about, right? You're thinking about more important issues that we might think. But the legislature requires Cal OSHA to develop and adopt a set of standards for the plan required. Okay, so Cal OSHA, they have to step in and provide some guidance here. But the deadline for them to do it is until December 31st, 2026. And all of you need to have plans in place. So assuming an exemption doesn't apply, by July of this year. But here's kind of what we can look back in the past to see how this might play out. So years ago, similar to this statute, Cal OSHA required employers to implement injury and illness prevention plans I talked about earlier. And many employers were looking at each other cross-eyed as to what those might look like. But Cal OSHA eventually published these injury, illness, and prevention plans, these model plans for employers to use. And those are available online. I could post a link to those if you want, but you can look under Cal OSHA, model IIP plans. And a lot of you probably still already have those in place. This is just another feature of that. Fortunately, the statute is quite detailed as to what is required, right? So, I mean, almost to an annoying level. There's a lot of detail as to what needs to be in these. I think the recommendation would be to seek legal counsel who can look closely at these, or yourselves look closely at the detailed statute. And I would imagine most of these will end up looking rather generic and substantively similar to each other, like most IAP plans do. Just as was the case there. But we'll talk more, I'm sure, about what needs to go into these plans and hopefully take the edge off some fears about what needs to be in these things and what doesn't need to be in these things.
Ryan, another component of this law, identifying people responsible for creating the plan. Do you have any guidance on who to choose and how many people should be involved in this?
Certainly, yeah. So to be clear, yeah, it requires employers to identify the people responsible for implementing the plan, not necessarily those responsible for creating the plan. So as I mentioned earlier, that could be done by your lawyer or anyone really, provided it includes the required criteria. So when it comes to identifying the people you have to choose to implement the plan once it's been created, this is something that is defined in the statute. And this would usually be done or performed by like an HR director type position or an operations manager. But if you don't have such a luxury, as I'm sure a lot of people online don't have that, it could be any manager or other employee who has the administrative ability and wherewithal to understand the plan, to take questions about the plan, to coordinate investigations. And again, we're envisioning very dramatic acts of violence this might cover, but it also includes a lot smaller issues, right? Between employees, acts of violence or threats to employees in the lunch hall, stuff like that. So someone who can coordinate investigations and ensure proper reporting and the like, right? So you can imagine maybe in your particular workforce who that person might be, who might be skilled and capable of doing that. It could also be more than one person under the statute. It could also just be a job title if you want to link that, whoever has that job title. But again, the persons or job title or titles, those need to be identified in the written plan. And again, the plan must ultimately be in writing and made available and easily accessible to all employees.
Yeah, and this sounds like a good opportunity for churches and nonprofit organizations that have either associations or denominational organizations that they could be of great assistance to their constituents by providing some education or templates on this sort of thing that may or may not be possible. But if they can, that would certainly help. Ryan, this plan is in addressing and preventing workplace violence. It seemed apparent to me, at least, that some kind of training needs to be a part of this. It's not that just that people are supposed to create documents and pass them out and put them in a file. Is it your understanding that some sort of security training is required or education as a part of this?
Yeah, it does. And so under subsection E of the statute, it addresses the type of training that employees must give to their employees. And in particular, the employer must provide employees with kind of an initial training when the plan's rolled out and then annually thereafter. So this is something that's going to be an ongoing practice. And the training must include how to report workplace violent incidents, how to identify the hazards that are specific to the employer's website, the corrective measures the employer has implemented. And to your point, it must include how to seek assistance to prevent or respond to violence and strategies to avoid physical harm. For this, I doubt Cal OSHA is envisioning employers to provide their employees with, combat or any sort of weapons training or anything like that. And what they're likely expecting employers is to include items like how to lock down a premises and who's responsible for calling security or law enforcement. So, security personnel are not required for preventative measures at the outset of the implementation of a workplace violence prevention plan. However, the statute states that a written plan on how to respond to actual or potential workplace violence emergencies, that those may include instructions on how to obtain help from security personnel. And this could be something as simple as having an arrangement with a particular security guard company and their contact information in the event of an incident. But whether or not such arrangement has been made with a private security company, the statute does seem to suggest that instructions on how to obtain help from law enforcement must be included in the written plans.
There have been a lot of good materials created to respond to the crisis of workplace violence that is seems to be breaking out increasingly. So we're not without any resources, but it doesn't sound like there's anything official that the state is suggesting at this point.
Yeah, other than the statute itself, I'm not aware of anything they've done, but stay tuned.
The law requires workplaces to keep records of incidents and investigations. Is there a template we use for this, and then what do we do with the records once we've created them?
So written records of specific instances of workplace violence, they must be kept in a particular manner and for a minimum of 5 years. The statute is pretty clear about the 9 specific items that must be included in the report. And these items include like the date and time and location of the incident, a detailed description of the incident, a classification of who committed the violent act or threat, including whether the perpetrator was a client or a customer, a family or friend of the client or customer, a stranger, things of that nature. Also, where the incident occurred, the consequences of the incident, such as whether security or law enforcement was contacted and their response, the actions taken to protect employees from a continuing threat or from any other hazard identified as a result of the incident. And then additional information about the person who's actually making the record, right? And the other civil code section of SB 553 deals with workplace violence restraining orders, right? So that's something that should probably be included in these plans, and is often a great tool that you have. Especially it's not often helpful for the more overt acts of violence, but when you get creepy, weird things happening that are, put an employer on notice, I got to protect my workplace. Just beware that is an option that's still on the table and should probably be included there. The question is what crosses a line, what triggers that? This is a tricky issue, especially here in California, because it rubs up against employee privacy rights. In particular, we have this California Labor Code section 96K, which provides protections for employees from discrimination for lawful conduct occurring during non-working hours away from the employee's premises, right? So if someone's doing something outside that's lawful outside the employee premises and they're discriminated against because of that, you can see that would be problematic, right? For gun type activity, right? So, I think it would be safe to say that, certain warning signs such as concealing or using a weapon at work, obviously, or any sort of physical assault, these will probably trigger the need to actually make a report. Intimidating or frightening others. This is one of those things that's all the books in the world couldn't contain all the conduct or describe the conduct that could be potentially threatening or disturbing. So it might be, you might have to leave somewhat the discretion of the person making those decisions, but just include the need that they need to be looking for these things. And, again, to be aware that employees also have their rights and don't be prodding around looking too much, and making decisions based purely on social media. But if you're aware of something that's threatening the workplace, it very well could trigger an obligation under the statute to make a report, to do an investigation.
I'm going to assume that if you're taking the time to document a potential problem, that it would behoove the employer to note that they've taken action to respond or address the problem. This isn't like simply to be a log of threats you noticed but did nothing about, right? That would perhaps set you back further than doing nothing.
Correct. If something is considered a workplace violence incident, which includes threats, right? Those need to be recorded, and the record could also say it turned out it was nothing, or something of that nature. But those, again, the detailed description of what needs to be in those reports, and again, retained for 5 years. Yeah, it's so I'd say over-report. It's generally my advice for most things in the employer world is to keep records, keep documents, and this is another reason and another kind of category where that should definitely be done. Make contemporaneous records, meaning at the time by those witness. This often can include witness statements. Sometimes that's something that needs to be done. Training on that might be necessary for whoever's responsible under the plan on how to conduct an investigation and how to make sure. And another important feature here is to make sure that people know they can't be retaliated against for participating in these things, right? So for providing a witness statement, even if it's against maybe their manager, right? They have to know that they have to be, notified they won't be retaliated against and not retaliated against for complying with this statute.
Thank you. And just a couple of notes. Thanks for some of the comments and questions. I received a note also here that if you're a Ministry Pacific client, or even if you're not, there is a specific coverage, liability coverage related to workplace violence that we do offer. And so you're welcome to consult with us to learn more about that. If you would like. It's not part of a standard liability property coverage, but it is something that's available. Ryan, you talked a little bit about the deadline, which is July 1st. Realistically, I'm sure you see this with clients all the time. A lot of people may not get it done. What happens if you don't get it done? What agency is overseeing this? Are they going to be knocking on doors and asking for copies of the plan? How do we go forward with this?
Yeah, so there's no affirmative duty to provide a copy of the plan at the outset, right? It just needs to an agency or anything like that. The statute's pretty clear that employees who aren't in compliance by the July 1st deadline, they can be technically issued a citation under the labor code, and they can be given a civil penalty and even be subject to a misdemeanor. So while I've yet to see anyone imprisoned for a labor code violation, it's technically possible, but yeah, compliance with this is due. I don't want to lull anyone to a false sense of security here, but the agencies are very much, from my experience, overrun. And we'll kind of see how if there's kind of a grace period given, or if they're going to come out, proverbially guns a-blazing, right? And trying to take down employers who aren't complying with this thing. Better safe than sorry to avoid these potential risks because they're out there. And whether and to what extent the Cal OSHA where they're going to focus their ire is to be seen. It's probably safe to say if you're not compliant, you probably won't, but you very well could technically be, and I think you mentioned, Roy, you have to provide this to them. Again, there's no affirmative duty to provide them your full plan, but if they ask for it, you do have to have your plan ready and available to provide it for them at any time. So just as employees need to be a copy of it, if anyone from Cal OSHA asks for it, you need to have that available. So
it doesn't have to be like this is the greatest plan that we could have possibly come up with. And it can never be amended. Essentially, you can put together enough framework of a plan to get started, and then you can continue to improve it as you have opportunity. I'm assuming that would be a reasonable approach.
I think that would be a reasonable approach. The labor commissioner is obviously more likely to be lenient with someone who's made an effort and tried to comply than someone who just completely hasn't done anything. And I think they're probably more likely to see the size of the employer and what the resources are. But if you put something together and refine it, like I said, I think the more you have, the better. But it will be a work in progress, I imagine.
Do want you to know Ministry Pacific is here to do free consultations with you regarding property and liability insurance. Also mentioned workplace violence related insurance. And of course, we'll continue to share resources. Ryan, as we're winding down our time here, what else is important? What else do people need to know about Senate Bill 553? Any misunderstandings we need to clarify?
No, I think you've done a good job of asking the right questions. I think we've covered the main features of the statute. Again, there's the creation of the plan. So just started kind of brainstorming and envisioning what's particular to your workforce. And then there's the writing down of the plan. Then there's the implementing the training element that we talked about, again, at the initial rollout and again on an annual basis for the employees. And then, having a reporting system in place. So hopefully you never have to make one of those. But if you do, that'll be something else. And those are the main kind of, I'd say, prongs of the statute. to be aware of. And I think we've talked the main pieces of each of those. Be careful, err on the side of compliance, in the constant presence of gray area. If I'm a betting man, like I said, usually these don't come through. A lot of people get away with non-compliance, but if it comes down and hits you, it could really hurt your business, and it could have financial implications. And for the third time, I mentioned now, I think the benefit of this statute is there are a lot of positive externalities, and this is a benefit that you could have for your congregations, for your employees, to the extent you could look at it that way. It's not the worst thing to be getting in place, right now.
One of our comments here from Linda, she says, some plan is better than nothing. I think it's beneficial to make sure employers address this with their staff, since it's very important. Very often there's a thought that it can't happen here. I think probably every workplace where there has been an outbreak of violence, people have thought it can't happen here. It's an opportunity to make some needed adjustments. Obviously, we'd like to do it on our own time frame instead of one imposed upon us, but that is the world that we live in. Ryan, another question I've seen a couple of times is our congregation, we don't have any employees. Everyone's a volunteer. Nobody gets paid. Do we need to do anything?
Mentioned earlier, if these are technically volunteers under the labor code, then you probably don't, because the small employer exemption might apply to you. But to the extent those are miscategorized volunteers and they're not, they don't meet the threshold of that, and they are employees for some reason, then usually employees have some expectation of some sort of compensation. But so if they're all but again, that's the caveat there. I think the bigger issue is usually with independent contractors, I think, is a bigger concern, more so than volunteers. And that's where we're seeing a lot of misclassification. So folks might say, look, we have these people that are not employees, they've signed, 1099s, and we're doing this through, they're not employees. Well, if the labor commissioner looks at it, or if they sued for, unemployment insurance, they might get it, in which case they would probably be considered employees. So yeah, I'd say independent contractors, the bigger risk. But if you're properly classified, everyone's properly classified, all else being equal, correct. If you have no employees, this wouldn't apply to you. It's never more confusing than at the rollout of a new statute. Usually you get attendant, direction, you get facts, sections from the agency who's, from Cal OSHA, that'll describe and answer these questions. A lot of the questions you all have make sense. You can expect some guidance on what is publicly, what does it mean to be publicly accessible? But I'm seeing some questions from folks saying, well, aren't all churches open to the public? So the exception would apply. The answer is probably. Again, the specific language for the small employer exemption is that a place of employment where there are less than 10 employees working at the place at any given time, and that are not accessible to the public. Okay. That's all you have. Public accessibility under various other statutes is defined, and is defined by courts. This one isn't defined greater than that. But I would think it's fair to say that, yeah, a church that's open to the public, generally anyone can walk in, that's going to be open to the public under the statute in all likelihood. Again, all the reason to be cautious of applying the 10-employee exemption.
We want to thank Ryan Abernethy of Weintraub Tobin for sharing his expertise today. The clock is ticking on this. Do what you can, get started, and you can set aside the areas where you need clarity, but it doesn't mean you can't do anything at all. So, Ryan, any final words for our attendees here today?
I think at this point, Roy's done a good job of kind of mapping out the safest and best approach here, given the limited data we have. So. And thank you all for having me. It's been great, enjoyable.
Thank you for helping us to kind of sleuth our way through difficult legislation and some things that aren't so clear. So we appreciate you sharing your expertise.